Okay, we will resume back in order. Your mic.
Thank you, Mr. Chairman. Mr. Warren, it might be helpful to try to put some numbers on these, and I'll get to some of the other numbers later. But under Dominion's Part A proposal, wouldn't the NOL carryover deferred tax asset at December 31, 2018 be around $800 million?
That's my recollection.
Now, putting aside the methodological disagreement that you have with Mr. Cullen, it appears that you conceded that the NOLC related tax deferred asset should be allocated between customers and shareholders.
If it weren't part of a structured plan, that's what I would anticipate. That's what I would expect.
Right, and we're looking on the screen at page 6 of your testimony, and you say that assuming the customer benefits plan was not a single indivisible economic plan, which it is, I agree with Mr. Cullen's basic premise that the NOLC-related DTA should be allocated between customers and shareholders.
As I said, that's what I would expect.
Thank you. Now, on page 25 of his rebuttal testimony, Mr. Cullen says, and I have it up on the screen, under the ORS calculation, only the NOL carry forward and the NOL ADIT, which, as we said before, means accumulated deferred income tax, related to the allowed costs are included for rate-making purposes. Isn't this a straightforward and logical approach?
Well, again, it's the one I would expect absent a comprehensive economic plan that treated it in some other way.
Now, going back to your testimony on page 6, you do say, and I acknowledge, you say, I strongly disagree that meaning Mr. Cullen's allocation methodology even comes close to achieving the proper balance. Isn't that right?
Yes, I do say that on page 6.
Thus, even though the two of you agree that the NOL carryover deferred tax asset should be allocated between ratepayers and shareholders, there is a difference between you and Mr. Cullen as to the proper methodology for determining the ratepayers versus the shareholders' share of the unutilized net operating loss carry forward. Isn't that right?
Well, that's the odd thing. I don't think there's a difference in basic methodology. I think it's, as I understand his methodology, he was trying to allocate it in proportion to the costs that each of the two groups would bear, which is what I did as well. I adopted his methodology and just used what I think are the right numbers.
Well, his methodology is that there needs to be a way to figure out how much of the deferred tax asset relates to the allowed cost versus the disallowed cost. Isn't that right?
Right, and that's what I did. I figured it out.
And on page 24 of his rebuttal testimony, he says that conceptually the right way to approach that allocation issue is to assume that the disallowed NND costs were never incurred and therefore never deducted. Isn't that right?
No, I see what you're saying, but I don't agree that that's the proper method. The proper method is to take, if that's not an allocation. An allocation is where you take the actual result and then divide it up, which is what I did.
Well, that's what you did, and that is one way to determine it. But in terms of figuring out what is the right amount of deferred tax asset to allocate to the allowed costs, Mr. Cullen his approach is that you conceptually assume the disallowed costs were never incurred and therefore never deducted.
Right, and that has the mathematical effect of presuming that the disallowed costs were the ones that created the net operating loss. So they're the last dollars deducted, and that's an ordering. Effectively, that creates an ordering mechanism whereby all of the deductions that the ratepayers claimed were the ones that offset taxable income, and all the deductions that the shareholders that relate to shareholder costs are the ones that created the net operating loss. And I don't agree that that's an allocation at all.
But his approach, his conceptual approach, as I've summarized it now, that is coherent, straightforward, and logical, isn't it?
I don't think it's logical. Is it coherent? I mean, yeah, I guess it's coherent. It's not, off the deep end, but it's just not equitable, and it doesn't reflect reality because there is no ordering of deductions. The deductions at the time, the deductions were claimed. Nobody knew if they were allowed, that they related to allowed costs or disallowed costs. They were just deductions.
Now, this disagreement between you and Mr. Colin appears to generate a very large difference between the two of you as to the amount of the net operating loss carry forward deferred tax asset. With you saying that the NOL carryover deferred tax asset at December 31, 2017 should be approximately $500 million, and Mr. Colin saying that NOL carryover deferred tax asset at December 31, 2018 should be approximately $67 million. And as previously noted, the larger the deferred tax asset, the more the ratepayers will have to pay. Isn't that right?
Yeah, that's correct.
Now on page 12 of your testimony, you show how you reached your $500 million figure. You took 60% of $2.35 billion, and that is $1.4 billion, and stated that this number equates to an NOL carryover deferred tax asset of $0.5 billion. Is that correct?
That's correct.
This calculation starts with a $2.35 billion NOL carryover number, which was the number as of December 31, 2017. Isn't that right?
Yes, that is correct.
So if we look at year-end 2018, that NOL carryover number is expected to be lower, approximately $2 billion, as you say on page 13 of your testimony. Is that correct?
Yes, that's correct.
And that year-end 2018 NOL carryover number, if multiplied by your 60% ratio, means that the NOL carryover deferred tax asset at December 31, 2018, according to you, would be around $460 million. Isn't that correct?
That's correct.
So as stated earlier, the alternative number that Mr. Colin calculated as of the same date, December 31, 2018, is $67.1 million. Isn't that right?
That is correct, yes.
Now, the way in which Mr. Colin got to his $67.1 million number is shown on his exhibit LK9, attached to his surrebuttal testimony. Have you looked at that exhibit?
I have. Let me see if I have it up here. I don't have it up here, though.
We've put it up on the screen.
Thank you, I guess.
Now, there are various columns that are... Do you remember looking at this before?
Yeah, I do.
And there are various columns that he has in this exhibit, and there's a column entitled, headed, 'ORS Recommend.' Do you see that?
I do.
Now, the columns to the left of that, one is the Dominion Merger Customer Benefits Plan. Then the second is the same plan corrected by ORS. Then the third is what he says is the merger CPB as you've calculated it. And then the Dominion SCNG no merger benefits plan. Every one of those, the first line in every one of those is that $5.4 billion. Isn't that right? It might be hard to see.
Yeah, except, well, in the first four columns.
First four, right.
5.4 billion, that's correct.
And whereas the ORS recommended number starts with the 2.865 billion number, which is the lower amount of N&D costs that ORS is proposing, and in Plan B, Dominion accedes to as the allowed N&D costs. Is that right?
That's approximately 60%, I believe.
And so if you look at the various columns, the four columns and then the other columns, then the ORS recommend column, and you compare them, it's the first two numbers that have been adjusted for the lower allowed N&D costs, and otherwise the Toshiba number is the same. The tax deduction, 2017 tax deduction number is the same, and same with the carryback of 2017. All those numbers are the same. Plus, if you look at right below, above the line, there's a 290 million number, and that is the same. So the only differences between those first four columns and the ORS recommend before we get to the line at the bottom is on those first two numbers, where the other columns start with the full NND amount, whereas ORS starts with assuming that only the allowed amounts are to be looked at. Isn't that correct?
Well, yeah, that's true certainly of the first two rows. The third row, which is the Toshiba offset, is the same all the way across.
Yes.
And that seems to be the big difference.
What is the big
So what you just said, the Toshiba, the treatment of the Toshiba.
No, the Toshiba is the same across, so I don't see any difference in the Toshiba number.
But for every other number, there is a difference across. The Toshiba number, all of a sudden, you'll notice that the first four columns are different than the last two columns in the first row and in the second row, but not in the third row.
That's correct.
So
The difference is in the first and second row. That's correct.
He's treating the Toshiba offset differently than he's treating everything else.
Well, the first two rows don't have anything to do with Toshiba offset. That's the third row.
I understand that.
Okay.
But he's not allocating that, even though that impacted the net operating loss carry forward.
Right. But everybody's treating Toshiba the same, according to this. All of the plans treat Toshiba the same, at the same dollar.
Well, okay, but they are, because it's treated as a element in the net operating loss carry forward in the first four columns, and then in the fifth and sixth column, he's saying the whole thing is attributable to disallowed costs, basically, and so again, there's an inconsistency in the way he treats everything else in the first four columns versus the last two columns, and the way he treats the Toshiba offset in the first four columns versus the last two columns. There's a scale down. You'll notice the 5.4 versus the 2.865, the 1.3 versus the 6.89, then all of a sudden the billion, the 1095 stays the same. It's not allocated at all. So I would think that is inconsistent.
But the Plan B of Dominion doesn't allocate the Toshiba amount between allowed or disallowed. It takes the full amount, even though the Plan B does accede to a 2.8 about number as the allowed NND costs, and therefore has a lot of disallowed.
But we're not talking at all about Plan A or Plan B here. We're talking about analyzing the associated NOLC outside of Plan A and Plan B. We know what Plan A and Plan B did. They did something unconventional. They didn't do this. And so we're saying that outside of Plan A and Plan B, if you were to do a proper and an equitable allocation of the net operating loss carry forward, how would you do it? And my approach was, we'll take the net operating loss, the total net operating loss carry forward as per the tax return, and then allocate it based on costs absorbed by customers, costs absorbed by shareholders. That's what I did. This does something different. This starts out by allocating a number of the elements, but not all of them. So some of them are allocated 60-40, and some of them are, and at least that one is allocated 100%. So it's not doing, and reference to Plan A or Plan B is not helpful, because Plan A or Plan B, neither Plan A nor Plan B had this allocation feature in it.
If we look at the ORS column, and we think about Mr. Cullen's conceptual approach, which is to assume that the disallowed NND costs were never incurred and therefore never deducted, his column is consistent with his conceptual approach, is it not?
I'm not quite sure what his conceptual approach is, but it might be. I will admit that it might be.
Let's look just at the full amount of the ORS column. And my last point on this is to show that if you go all the way to the bottom of that column, you go one number up, you come to that $67.1 million. And what I'm trying to show here is that those mathematical calculations that Mr. Cullen made is how he gets to his $67.1 million. Do you see that?
Well, I'll confirm that he used mathematics to get there.
Okay. Let's recap the numbers for the benefit of all of us, just to make sure we agree as to the difference here on this issue. On the NOL carryover deferred tax asset at December 31, 2018. As proposed in Dominion's Plan A, that number is $800 million. As proposed by you, it's $460 million. As proposed by Mr. Cullen, it's approximately $67 million. And Dominion's Plan B proposes that the number should be around $600 million. Does this sound right to you?
It does sound right, yes.
These are very large differences that could have a big impact on the rates that the ratepayers will have to pay. Is that not true?
Well, again, it depends on whether, if you are rate setting from the outset without a comprehensive plan that's been offered as a single solution, then yes, if I was just setting rates and this was the data that I was using to setting rates, yes, it would make a difference. Now, with respect to Plan A and or Plan B, the rate is the outcome of the plan. That's what the plan will provide for, and the 800 million or 600 million is reflected in that plan. It's only when you start disaggregating the plan and identifying and analyzing this particular piece of it separate and distinct without regard to the rest of it that you could say that it would change things. And I would say that if $67.1 million were the right number, which I don't think it is under any circumstances, then that's not the plan. The plan would have to accommodate that, and it would be a different plan.
Let's move on to another area of disagreement between you and Mr. Cullen relating to the NOL carryover deferred tax asset arising from the abandonment deduction. As I understand it, SCE&G's net operating loss in 2017 could at least theoretically be attributable to the abandonment deduction taken in 2017 and or to the accelerated depreciation taken in 2017, depending upon which deduction is deemed to be the last deduction. Is that right? It could be conceptually assigned to any deduction it claimed, but those are the two big categories of deductions that that SCE&G claimed in 2017. But it claimed a lot of other deductions. Right. And you say that the 2017 accelerated depreciation should be deemed the last deduction, and Mr. Cullen says that the abandonment deduction should be deemed the last deduction. Is that correct?
No, I don't say that the accelerated depreciation should be deemed the last deduction. What I say is we're all operating, when we do these allocations, we're all operating on the presumption that the NND cost deductions are the last deductions taken. They're the ones that caused the net operating loss carry forward. What I do say in my testimony is, from an IRS perspective, and this the IRS, when it has dealt with situations with net operating loss carry forwards in other contexts, has viewed the last deductions taken for the purposes of the normalization analysis as being accelerated depreciation, which just means that we have two different worldviews. We have an IRS worldview that they are using through their normalization lens, and we have a different worldview. We have the NND deduction as the last ones claimed for our purposes, which are different than the IRS's purposes.
Yeah, looking at your summary that you read today, on page 2, you say that in 2017, SCE&G generated a large NOLC due to the large NND-related deductions it claimed in that year. That's consistent with what you just said, right?
Yes.
And the issue we're talking about here relates to the so-called tax normalization rules. Is that right?
That's correct.
And the tax normalization rules concern the proper treatment by utilities of accelerated depreciation, right?
That's correct.
And effectively, the dispute between you and Mr. Cullen on this issue is whether the abandonment deduction or the accelerated depreciation should be deemed the last deduction. Is that right?
Well, I don't know that we have a dispute. All I'm pointing out, I don't think he disagrees. I don't think he disagrees that the IRS's view is that accelerated depreciation is the last deduction taken, although he may have said that, but they've never said that where there was an abandonment deduction. And that's possible, and in fact, it's true. I mean, the situation where there was both an abandonment deduction and accelerated depreciation has not, to my knowledge, been the subject of a ruling or a pronouncement. But nevertheless, 7 or 8 times in the last couple of years, the IRS has said that for normalization purposes, the last deduction taken is accelerated depreciation. And I'm willing to take them at their word.
But none of those rulings involved an abandonment deduction. Isn't that correct?
That's correct. That's what I said.
And to your knowledge, there's no other IRS guidance that deals with this question in the context of an abandonment deduction.
Not in the context of an abandonment deduction.
And generally, private letter rulings are not to be viewed as stating the official position of the IRS with respect to any issue and only benefit the taxpayer that requests the ruling. Isn't that right?
Well, sometimes they benefit the taxpayer, sometimes they don't. But they are taxpayer specific. They are providing guidance to a specific taxpayer, and they are not precedential. On the other hand, if you issue 7 of them that say the same thing, within a year, you get a pretty good sense of what the IRS believes.
But again, those 7 all relate to a circumstance where there's no abandonment deduction.
That's correct, yes.
And also, a private letter ruling issued by the IRS does not control how a court might decide this issue if it were faced with this issue, would it?
No, it's not binding on anybody other than the IRS and the taxpayer to whom it's issued.
So in the absence of definitive IRS or court guidance, the Commission could elect to use Mr. Cullen's approach, right?
The Commission, whether or not there was a ruling that addressed both abandonment and the IRS doesn't control the Commission. All the IRS can do is penalize the company. And so the Commission has its discretion, in a sense, to do anything it wants at any time. But there are tax consequences, or maybe tax consequences. And in this instance, they can adopt the Mr. Collins' proposal, and there may be tax consequences for doing that.
Let's look at what SCE&G itself said in Exhibit LK7, which was attached to Mr. Cullen's surrebuttal testimony. And I have that up there. And what it says is the company, meaning SCE&G, has considered the NOL ADIT asset as being fully allocable to the N&D project costs. The company would not be in an NOL situation but for costs associated with the N&D project. So SCE&G is taking the position it's the NOL, it's the N&D costs, abandonment deduction that created the NOL, not any accelerated depreciation.
We're all taking that position. It's only the IRS that would take a different position.
Might take a different position.
Well, okay, might take a different position for purposes of the normalization rules.
As to the dollar impact of this dispute or disagreement, you say on page 15 of your testimony that Mr. Collins proposed $67.1 million for the NOL carryover deferred tax asset is too low a number, but you do not say how much of an addition would be needed to fix the alleged problem, do you?
I do not.
And Mr. Cullen, on page 30 of his surrebuttal testimony, does provide a calculation of the amount that would fix it, the alternative amount that would fix it. Isn't that right?
Bear with me for just a second. He does propose a hypothetical situation in which the problem is that the NOL was created in 2017, not in 2018. 2018 may have absorbed some of it. The question is, in 2017, when the NOL was created, what was the deferred tax asset that needed to be recognized? So taking a look at what happens in 2018 when the NOL was not created but is used really doesn't answer the question.
But doesn't he say on page 30, the NOL ADIT required would be approximately $100 million or less, and that is in lieu of the $67 million number he was suggesting. That is assuming you end up being right about the tax normalization.
Well, that's what he says.
Okay. And so at least his calculation compared to the $67 million indicates this is about a $30 million issue, and that if the IRS prevails on this issue, that there would need to be an increase in the ADIT from 67 to about 100 million. Isn't that what he's calculated here?
Well, what he said, I mean, again, he's looking at 2018. He's not looking at the year in which the net operating loss was created, which is really the year to which you should look. So it's, and then if the IRS prevails, you don't just add another $30 million to rate base. If the IRS prevails and you violated the normalization rules, you lose accelerated depreciation. So there's it's not like saying we only have a $30 million issue here. The issue here is whether we are compliant with the normalization rules or not. And if you're not complying with the normalization rules, then you lose all accelerated depreciation. And you don't have to worry about deferred taxes anymore because they're going to go away. So to characterize this as a $30 million problem, I think minimizes the importance of getting this right.
But as I asked earlier and you answered, you have not calculated the amount that would be needed to fix this problem.
The purpose of this section of my testimony was simply to point out that there was another, not a prime mover here. This is not the reason we ought to do what I proposed that we do. But this is an add-on that, by the way, Mr. Collins' number, which I believe is grossly understated, also would run afoul of this other or introduce another factor, another detrimental factor, potentially detrimental factor into the mix here that everyone wants to avoid, whereas my allocation methodology would not cause that problem.
And your allocation methodology generated a $460 million deferred tax asset at year-end 2018, right?
That's correct.
What will be the minimum? Have you calculated the minimum amount of deferred tax asset at year-end 2018 that would be needed to fix this normalization issue if it ever arose?
I have not.
Okay. Let's turn to another subject, and that is that in the merger customer benefits plan, the applicants, Dominion Energy and SCNG, proposed a one-time rate credit of $1.3 billion. Isn't that correct?
Yes, I believe so.
And if this credit is paid, assuming that's the plan that goes forward, it would give rise to an income tax deduction and would reduce the utility's taxable income and may create an NOL associated with it, right?
Well, are you assuming that it's all paid in 1 year?
That's my understanding of how the Plan A would work,
Okay.
is that it would all go out in 1 year.
Well, the answer is we hope so. There is a question as to whether the refund would be considered by the Internal Revenue Service to be a deductible payment or a payment that facilitates the the merger, but assuming, and I believe the company is seeking guidance on that, but we can take the we can take your premise that let's assume that it's a deductible.
Yeah, let's assume it's a deductible, and it were to become an additional NOL carry forward, deferred tax asset. Wouldn't the amount of that additional deferred tax asset be $324 million, which is $1.3 billion times 24.95% federal and state income tax?
Would you repeat the question, please?
I'm sorry, it is rather long. Assuming that it's deductible with the $1.3 billion, then I'm trying to get to an estimate of what the deferred tax asset NOL would be associated with that, and I think that it would be $324 million, which is $1.3 billion times the federal and state income tax rate.
That may be so, but it's my understanding that the $1.3 billion is not being included in rates at all. That ratepayers will have no impact from that.
Yeah, and I think Mr. Colin has raised the issue to make sure that all the parties are on the same page, because he's expressed concern about whether or not SCNG intends to record this additional $324 million as additional NOL carry over deferred tax asset. Isn't that right? He's expressed that concern.
Okay.
And you say in response, in your testimony, that under the merger's customer benefits plan, the $1.3 billion payment is funded by shareholders.
Yes.
And to the extent the $1.3 billion rate credit generates or adds to SCE&G's NOL carryover, that portion of the NOL deferred tax asset for tax purposes will not, for rate-making purposes, increase the NOL carryover deferred tax asset. Do you remember that?
I do, and that is my understanding of the way the company proposes to treat it.
And does your client agree with that? That it will not add it to deferred tax asset?
I thought so, or I wouldn't have said it in my testimony, but you should ask somebody when you have the opportunity from the company.
Do you agree that the exclusion for rate-making purposes of any deferred tax asset relating to the $1.3 billion should be included in the commitments and conditions adopted by the Commission in this proceeding if it approves Plan A?
I'm entirely agnostic. It could, you could, or I don't know any reason why it would be better to do so than not do so. But okay, you should again ask a company witness that question.
Mr. Reed.
Yes, Mr. Chairman, just to try to speed this along. If Mr. Warren is correct, we wouldn't have had him make that statement in his testimony if the company didn't agree to it, and we would agree to that commitment.
Thank you.
In that case, yes.
Okay. Excellent. The last issue. There's a difference between you and Mr. Colin concerning the period over which the unprotected plant-related excess deferred income taxes should be amortized, which I think you summarized in your summary, with Mr. Colin recommending a 5-year amortization period and you and SCNG recommending an approximate 30-year amortization period. Isn't that correct?
Yes, that's correct.
The only question I have on this is you both seem to agree that the correct amortization period for this item is completely within the discretion of the Commission. Is that correct?
That is correct.
Thank you. I have no further questions.
Thank you. Mr. Cleveland, I think you stood up next.
Thank you, Mr. Chairman. 'Cause 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 ' Mr. Chairman, I will try to be done before noon so we can all go to lunch in a timely fashion, and I promise not to talk about taxes at all.
Well,
Thank you.
that's a great plan, Mr. Cleveland.
Could I get the Elmo, please? Thank you. Mr. Chapman, this is your summary, so I'm going to start there. This is page 4, lines 17 through 22. And you state specifically that securitizing the NND debt, as witnesses have testified, removes any equity return on the investment in the future. Is that correct?
Correct.
And you go on to say that securitizing it would preclude Dominion from closing the merger with SCANA, given the need for an appropriate return to our shareholders from this transaction. Is that correct?
That's also correct.
Would you agree that if it turns out that securitization does not adversely affect the company's cost of capital and does not adversely affect the company's credit rating, and if the Commission did it, and if the General Assembly passed legislation, it would ultimately lower total customer costs?
I don't believe that's relevant to this proceeding, given the consideration of a package of significant customer benefits which are financed by Dominion Energy's balance sheet. There's simply a need for an adequate return on that investment, which a securitization financing transaction does not provide.
Okay, I want to talk about that a little bit. Dominion did not provide any capital for the nuclear development project, did it?
No.
And Dominion did not incur any risk when SC started this project, did it?
Dominion Energy did not.
Okay. But it's your testimony, and the VC Summer project will never be used and useful, correct?
That's my understanding.
But it's your testimony that Dominion shareholders deserve an appropriate return for the nuclear development project?
The Dominion Energy shareholders deserve an appropriate return for the capital they're investing in the state of South Carolina through this joint application.
Okay, but does that include that they have a right to a rate of return on a project where they invested no capital and took no risk?
The application sets out economic returns that provide for an adequately capitalized balance sheet of South Carolina Electric and Gas, which under the joint application would become a consolidated subsidiary of Dominion Energy.
I don't think that answers my question.
Can you repeat the question, please?
Do you think that Dominion shareholders are entitled to a rate of return for a project where they invested no capital and took no risk?
Dominion Energy shareholder capital would be invested in this transaction, and they deserve a return on that capital. So a little bit, I know it's not an exact response to your question, but that's the situation.
And then so the capital you're talking about there is the capital that shareholders are investing to acquire SCANA?
To provide for the customer benefit, the benefits associated with the merger with SCANA.
Okay. When you were speaking with Ms. Edwards, she asked you whether the company, if the merger goes through, would have be fully transparent with ORS and the Commission. Do you remember that?
I do.
And you said that you were unaware of any time in your history with the company where that was not the case? Is that a fair representation of what you said?
I can't remember my exact quote, but that's the spirit of it.
Okay. And you're the Chief Financial Officer?
I am.
Okay. Were you with the company in 2014?
I was.
Okay. Are you aware of legislation that was passed in 2014 regarding nuclear costs in Virginia?
Not very aware.
You're not. Okay. So you don't know about a bill that allowed Dominion to write off certain nuclear expenses?
By not very aware, I'm generally aware of that history.
Okay. This is a 2014 Washington Post article where Dominion spokesman David Botkins is quoted as talking about the bill, and he says customers are the winners with this bill. And this is right here. Because it helps facilitate the building of another nuclear unit at Dominion's North Anna plant. Do you know about that bill?
Again, I'm generally familiar, yes.
And down here, Steve Hayner, a lobbyist for Newport News, is quoted as saying, this bill sends a signal to the commission being that if the commission doesn't like, or if the company doesn't like the way that rate case comes out, if the company doesn't like the way the rules are shaping up to come out, the company will just come down here and change the rules. Do you see that?
I see it.
Do you have any idea what he's talking about?
I'm not, again, I have very general recollection of this issue. So I
Okay.
don't.
Well, this article says that by writing off 70% of the nearly $600 million that Dominion says has been spent on the nuclear and wind generation project between 2007 and 2013, Dominion can avoid a possible refund to customers in 2015 and a rate cut in 2017. Do you know if that's an accurate representation of what the bill did?
I do not know.
Okay, thank you. You were the CFO this year, is that correct?
I'm currently the CFO, yes.
But have you been CFO since beginning of 2018?
No.
When did you start being the CFO?
November 1st.
Of this month?
I've been involved in this case and scheduled to be a witness in my role, of my previous role as treasurer. And as of November 1st of this month, I became chief financial officer and treasurer.
In your role as treasurer, were you aware of the company's lobbying expenses?
Not specifically.
This is an AP report from this year that reports that the Dominion, which is the first highlighted part, the state's biggest electricity utility and most politically powerful company spent more than $1 million on lobbyists, entertainment, meals, and communications from May 2017 to the end of April 2018. As treasurer, do you know if that's accurate? Or CFO?
I do not know if that number is accurate.
Do you know if it's accurate that the spending in that period was 10 times what the company said it was spending in the last year's filing?
Your Honor, Mr. Chairman, I just object on grounds of relevance. I'm not sure what lobbying expenses in Virginia have to do with the issues before the commission.
Sustained. Let's move on.
Mr. Pruitt, is that correct?
That's right.
Okay. This is page 1 of your summary, and you're talking about the differences between Plan A and Plan B. Is that correct?
That's right.
Okay. And the highlighted portion says that Plan B is appreciably less than the approximately $137 bill under the originally proposed Plan A. Is that correct?
That's what it reads.
Okay. So the company proposed Plan A at the beginning and has now proposed Plan B, which, according to the company, is appreciably less than in terms of cost to customers than Plan A. So why are we even talking about Plan A?
Well, we can't isolate just one component of the plan. Plan A has, multiple components. One of them is the $1.3 billion cash that we're giving out upfront. So you got to take all that in conjunction while comparing. Just on the bill, Plan B is lower, but combined from an overall perspective, we believe both plans are substantially similar.
Plan B is substantially lower in cost to customers, but you think they're substantially similar?
In the customer bill, the cost to customers, we need to account for the $1.3 billion we're paying to them, which is $1,000 per residential customer on an average.
This is page 2 of your summary. You state that Dominion Energy is not conceding that any of SCE&G's investments were imprudent. Is that correct?
That's what it reads, yes.
Has Dominion done any independent analysis of the prudency of any of these project costs?
We have not done an independent analysis, or at least to my knowledge.
At the end of page 2, going over onto page 3, it says, in short, the ORS plan fails to strike a fair and appropriate balance between the need to provide significant rate relief and the need to maintain the viability of the utility. Do you still agree with that?
I do.
And you're aware that part of ORS's plan is a claim that a lot of these costs were imprudent, correct?
I'm aware of the claim.
So, and I asked somebody else this earlier, my question to you is, if the commission finds that those costs were imprudent, do you think it is necessary to be fair and appropriate to charge customers for those imprudent costs just to protect the viability of the utility?
I think what Plan B says is that, without conceding to any of that, in Plan B, we're assuming the same date as ORS is assuming, which is March 12, 2015, for the capital to be recovered, so that the debate about prudency goes away. So I think Plan B, we're not recovering anything that the ORS considered imprudent.
Okay, Plan B, I agree with you on that. But let's talk about Plan A. If the commission finds that some of those costs were imprudent, does that mean the company should just withdraw Plan A because it requires charging customers for some of those costs? Or would the company still prefer Plan A?
From my perspective, there's both plans are packages. One of them has certain things that ORS wanted, that's Plan B. For example, the date after which costs were considered imprudent. Between Plan A and Plan B, we're indifferent, right? It provides a package to customers in terms of value. One provides cash up front, one provides cash over time.
Yeah, and I'm going to ask this one more time, and this will be the last time, Mr. Chairman. If the commission finds these costs imprudent, do you think that Plan A is a fair and appropriate balance?
If the commission determines as imprudent, I would think it should be disallowed, yeah.
Okay, thank you. No further questions.
Thank you. Okay, we're going to go to lunch. We'll be back at 1:14.